To all of you, first I introduce myself. I am practicing as an advocate, and apart from it I am also a chartered accountant and computer forensic expert. So I would say where one has to integrate bit and byte with debit, credit, with law, there I have a total domain. So we are going to discuss about the admissibility of electronic evidence, which is as of now the biggest challenge. You may have best of the answers. I tell you about a case. This is a recent case. In one of the cases, CBI has filed a charge, and the case was of anti-corruption. There were audio files, video files, supporting the prosecution case. The person who is giving the money, who is taking the money, they are captured in video. Now police filed the charge sheet along with the video files, audio files in CD. But our evidence act says it should be accompanied by a certificate under section 65B of the Evidence Act. But they did not file that certificate. And what was the fate of that case? When the case went to the court, court simply discharged them. Even no trial took place. Even no charge was framed. So the same position I am finding in most of the companies. Whenever they are taking the backup of data, they are not adhering to the standard of evidence which is required by the law. So when you will go to the court of law, you might be maintaining the ample of data in server, but you will find that not even a single data is admissible in court of law. I tell you another case, recent case. One of the corporate in Delhi, they scanned all the documents, archived them. This was the record for last 10 years. So they spent crore of rupees on that. Then they took the printout and filed in the court of law. When the matter came for the judgment, the court held that these documents are not admissible. So in the law, the scanned documents are not admissible. Similarly, if you are taking the backup of data, now if you are taking the electronic backup or manual backup, it makes a difference. If you are taking the manual backup, then you need to maintain the original copy of the data, apart from the manual backup. But if you have not maintained the original copy, then it is not admissible. Similarly, if you are taking the electronic backup, then both the copies would be admissible. So in this session, we are going to cover about what is the electronic evidence, because we all might have studied about the electronic evidence in our CA, SSP or other examination, but in the law it has a different perspective. So whenever we have to see whether our data is admissible or whether it constitutes electronic evidence or not, we have to see in perspective of our national laws. Then what are the principles which are required to be followed in case of digital evidence? Electronic records and their admissibility. I will discuss about one or two sections which are very important and which I want every one of you to know if you are working into IT field. Because one of the biggest, another challenge is, since police agencies and even legal fraternity is not in a position to understand the electronic evidence. So this burden is being shifted to the IT department. So whatever cases I am doing on behalf of companies, so in every case, even if I talk to the company, even to their legal department, they always say, okay, please talk to our IT department. They will tell you whether how it is being maintained. So it is more important for the IT professionals to know how to maintain it so that it would be admissible in the court when required. Then I am going to discuss each type of evidence and how to make it admissible in the court of law. So first I am coming to what are the major challenges. So the first challenge is identifying the electronic evidence. So I tell you one case, interesting case. An FIR was registered on the complaint of Sanjay Kapoor, the famous actor. The FIR was for threatening through email and also for extortion of money. He filed a complaint, case was registered. The police located the IP address, they went to the Rediff. Rediff provided them IP address and MAC address. So they conducted the raid at a cyber cafe in Mumbai. They seized every computer. Send all the computer to the forensic lab. But MAC address which was provided by the Rediff did not match with the MAC address of any of the computers. So what could be the reason?
Max 2 feet.
Anyone else? It's a very simple reason, because they have not seen the model.
They have
Not seen the model. Because once it is through modem, so only the MAC address of the modem is captured by the eyes.
Exactly.
Now this has become the ground for acquittal in that case.
Okay.
Second challenge, and the bigger challenge, is now you have identified the electronic evidence, but how to seize it and how to preserve it. I tell you another case. An FIR was registered against the former Chief Minister of Punjab, Amarinder Singh. It was a case of corruption going into hundreds of crores.
It's very common. Very common.
Very good. So police conducted the raid, and by luck they found one pen drive which contained a program in Fox Pro. And in that particular pen drive, there was complete data, whatever amount they have got, how it has been divided, what is its destination. So on the basis of that pen drive, that charge sheet was filed. The defense moved the application for mirror image, because now you have a right to get the mirror image. And luckily I got the opportunity to do the forensic analysis of that pen drive. So what I find? That pen drive was being accessed by the police 4 days after the seizure. So seizure was on 22nd of June of that particular year, and till 26th of June they were accessing it.
Tampering evidence.
Integrity goes, chain of custody is broken,
Exactly.
no authenticity. Now ultimately the case will go for acquittal.
Yeah. So they were not used. So that happens in a lot of cases, right?
Most of cases.
Yeah, these guys.
Because normally even police officer comes to me
Yeah.
with a laptop. Sir, there is evidence, how to find it. When I ask them, from where you get it? We have seen it from the accused. Where is the accused? Is into Tihar jail. When you have seized? On last Sunday. In the seizure memo, chain of custody form, it is written that it is sealed, stamped and deposited into the Malkhana. But now they are carrying it.
Yeah, happens.
Third challenge comes at the stage of forensic analysis. This is a bigger area. Because if you know how to read the forensic report and what could be the challenges, 90% of the cases can be broken at this stage. I tell you one of the latest cases which I am doing. It is a case of theft of source code, which is into C++. So I learned the C++. I am doing cross examination on that. In this case, the forensic expert, for comparing the source code, have used one software, Resource Hacker. This is available for free.
Yeah.
Right? Now the question is, when the prosecution come into the court, I ask, what is the authenticity of that source? Whether you have a source code, whether you have any source from where you purchase, whether there is any person who can come to the court and depose that this software is for that particular designated purpose, whether it complies with the Daubert principle, because the Daubert principle is the main principle which is required to be followed for analysis, and every forensic software has to adhere it. So if you are using the open source software which did not have any authenticity, your forensic report would be of no use. Now the question is, what is the solution? But if you have open source software, you can certainly download the source code and you can put it along with your report. Because then the burden shift to the defense. See, this is the source code which we have used. Tell us how it is not proper, or how it is not compatible. And fourth and the biggest is the presenting the evidence in the court of law, which I was discussing with you, that in case of with the audio and CDO files both. In the videos you can see the person is taking the bribe, but the court said no, it is not admissible. He is going scot free. So these are the one main challenges as far as the admissibility of electronic evidence is concerned. So in this session we would be zeroing on presenting the evidence in the court of law. So this is the question for you. What should you present?
complete computer.
I think memory should be one of the things that should be preserved.
Yeah, memory can be preserved, but only when you get a computer which is on. But otherwise, what you will procure? What you will preserve?
Hard disk.
I will preserve complete
All the
computers,
three-
all the connections,
the
labels,
entire-
photographs
the
taken.
entire-
See, what is the practice which is now going on is that they only see the hard disk.
That's not the right practice.
Okay? And even if they go to the forensic lab, they will say, we don't want anything else.
Just the hard disk.
Get it out the hard disk and give it to us.
Sir, how do you
And-
spell? Sorry, how do you spell Dalbert principle?
DABY.
Thank you.
I tell you one of the latest case of the ED, Directorate of Enforcement. In one of case, they conducted the raid and they seized the hard disk. It's case of only about October or November. So when the mirror image was analyzed by them, they got all the files which are expected to be created in 2015, but all the files were of 2011. So what could be the reason?
Date change over.
Cloak has been managed. Because you can put your cloak into the back date.
Yeah.
But now the question is, as a forensic examiner, how can I prove that it is into a back date? What I require?
Bias का चाहिए
Bias.
तरीके.
So if you have seized only the hard disk, you can never authenticate the time clock, and if particularly there is a gap in time between the actual files, actual time at the time of the computer, you can never prove.
Sir, but in all the literature, so I also have a forensics master's from Purdue. I think I've told you already. So we were taught. So my professor Rogers, he always taught whenever you are seizing evidence. So we had a bag and tag lab. So in which we used to actually tag all the connections.
You see,
Right.
everything, international principle is that you will take the photograph, you will
Yes.
see everything, and even you will tag every connection so that you can rebuild
It
the
is
scene
connected, yeah.
into your labs. These
So-
are the international principles.
Hard drive was shown to be connected to the PC. This is the PC of the person, and फिर BIOS का लेके and then.
So there are big challenges. I tell you another challenge, which I have raised in one of the case, from the same case of source code data set. The CBI has conducted the raid and recovered the hard disk from my client. Hard disk bears serial number and everything. But in the chain of custody form, they did not write the either make, model, serial number. They give it a mark B and they have written hard disk marked as B. Now the first issue which I have raised, this is not the hard disk which is seized from me. They can never prove it. So we have a number of issues. So we are coming to the evidence of, definition of digital evidence. So these are the definitions from some of the prominent websites which lay down the procedural law relating to the evidence. And the definition is more or less of the same nature, information which is into the binary form and is being used in the court of law. So this is the most common definition. But now let us see what is the definition which is given by the court. So I have given you 3 sections, and this is the most important section. Because when we come to the law does not identify electronic evidence. In the entire Evidence Act, Criminal Procedure Code, or any of our laws, word digital evidence is nowhere used. How you will identify whether a particular evidence is digital evidence or not? So, no identify the word electronic record. So, if a particular gadget or things falls within the definition of electronic record, then it is electronic evidence. So, what is the requirement? Electronic records means the data which is generated in electronic form, or otherwise we can say in optical or magnetic medium. So, this is a simple thing. Then we have section 7 which deals with the metadata. It says whenever a company is maintaining the record, retention of record, so it has to be maintained only in the original form. So when we read all these 3 together, so that means the data which is actually generated into the electronic form in original. So I am comparing it with the scanned document. which I have discussed in the beginning. In case of scanned document, what is into original physical data? Now if you want to verify whether this data is genuine or not, in case of scanned document, you have to see the original document which is into the physical form. And in other cases where the data is generated in electronic form, you have to maintain the metadata, because section 7 also says you are required to maintain the data which can prove the source and origin of the data. So that means it should be to that extent that if required, forensic of that data could be done, which is still a big challenge in case of cloud. So if we apply the same analogy, the evidence in the cloud will not be admissible. So till now in the Indian Evidence Act, we don't have any provision authenticating the data in cloud. So if cloud is in India, certainly you can say it is original is into the India, and opposite party can see, can inspect, and if required the forensic can also be done. But if it is in foreign country, it is into the somebody else's custodian, so it may not be. So the requirement for proving the electronic evidence, the first requirement is the electronic admissibility of evidence, then would be establishing the chain of custody that we have discussed in the case of Amrinder Singh and other cases. So for proving the admissibility of evidence, the first thing is evidence should be either primary or secondary. So what is the primary? Original. If we are talking about the computer, it's hard disk which contains the data. That is the primary. And what is the secondary? We can take it to printout. We can transfer this data into CD, DVD, pen drive. They will be scanned. Then we need to prove the source, reliability, and authenticity. If all these four things are established, then it would be admissible in court. Otherwise, it would not be admissible.
So these are four primary factors.
For primary. So now for digital evidence, we have a separate principle which are required to be followed. They are not applicable to other type of evidence. Yes, please.
So to ask you in a scenario where when we say when we use terms like chain of custody, to take an example, a file in a hard disk, let's say a video recording of a.
But let me complete 4 or 5 other slides. Then it may be possible that I could have answered your question. Otherwise, we will take it. So the first thing is no action should be taken on the original. So as we have discussed in case of Amrinder Singh, and you will find in most of the cases. And whatever the forensic report which are being filed in the court of law, you will find that in none of the report the forensic lab ever give an opinion that what was the last access date. Whether the hard disk or particular media have been accessed after the date of seizure. Because now all the forensic software provides you that particular utility. You can put a date that whether what are the files which have been accessed during a particular period. But they will never give it. And if you will get the mirror image and analyze it, you will find that in at least in 90% of the cases, it has been accessed after the date of seizure. Second is, now there may be cases when you need to access. You can simply take the example of taking the RAM dump. If you are taking the RAM dump, all the time you ignore it, you need to access it. Then the law says if you are accessing it, you must be competent to do it. You must know the ramification of your action. If you are taking the RAM dump, you need to make sure that your software should be in an external pen drive. It should be run as an administrator. The data should be directly exported to external media. So you should be in a position to explain if you are accessing that particular electronic evidence. Then you need to maintain the audit trail. Even if you have accessed because of some requirement, because of some contingency, you don't have a software to make the mirror image, and case is something crucial like official secret act, you need to identify who are the other person who have taken the data. So there may be circumstances where justifying the access to the original media, but then that should be done by competent person and audit trail should be applied to it. That means it should be mentioned into the chain of custody form or the seizure form, whatever the form you are maintaining for that. Person in charge, who is the person who is doing the entire process, has the responsibility. Because if there is any manipulation, he would be liable for that. On the later stage, the accused may sue him, file a case for defamation, can initiate a criminal, even criminal proceeding against him. Then we have the procedure for seizing the electronic evidence. The first thing is physical control of the scene. We all are aware that by single click, data can be deleted, formatted, wiped. So that is the one of the main requirement for maintaining the chain of evidence. Second is the volatile and non-volatile evidence collection. As of now, taking the RAM dump is very easy. RAM dump provides you a lot of information, and particularly if there is some encryption or something, you may get the password from the RAM dump. Still in India, people are not aware about, investigation agencies and the legal fraternity is not aware about the encryption. Once they see the hard disk, they think that they have done something big. And what happens? Then they send it to the FSL. After 3 years, FSL sends the report, we are unable to access it, and the matter is gone. Even nobody goes to saying that there is some encryption. And recently in the US, there are a few judgments which says, if the data is encrypted, the accused will not be granted the bail till he provides the password or decrypt it. This is a big gap in our law, which I am recommending to the Law Commission to amend it and to have the corresponding law. So
in the US we have a law, Fourth Amendment we call it. So if the hard disk is encrypted, the agencies cannot tell me to actually provide the key, because that might be.
But there are not two judgments have recently come. I have the judgment. Where I will give it to you. Particularly in case of child pornography, they have given the finding that until he will decrypt it or will give the password, he will not be granted that. So there are two letters that
So there's nothing like that. So basically you are saying if I have encrypted hard drive, so as per the law, I'm not aware because I'm kind of currently not very active in the forensics and the law community for the past couple of years. But what I understood from your contention is that if I have my TrueCrypt installed on my machine and somehow someone has a motive, let's say that way, then they can just put you behind bars and they can say give the password, or you will be behind bars, you won't be granted bail.
See, safeguard can be inbuilt in, like for taking the voice sample. Now the safeguard is voice sample can be only taken with the permission of court. Otherwise it cannot be taken. So similar safeguard can be put into that. That if you want the password for encrypted volume, the permission of the court is required to be taken. Then court would apply its mind whether the offence is there, whether the evidence is connected to it, whether the prosecution agency justified it, then it can pass over. Only the thing that there should be certain procedure to do that.
Yeah, so basically our phones are encrypted. All of us use Androids and Blackberries and iPhones, and they are technically encrypted hard drives.
Yeah, I agree with you, but you see, if a person has committed an offence which is very serious, kidnapping, murder and something like that, and the data is required in the interest of justice, then there might be some due procedure for having that data. So we can put the procedure with the appropriate safeguard so that even the privacy is maintained, and wherever the law required, that data should be available to the investigation agencies. Because otherwise what is happening? Why the cybercrime is exponentially rising? That there are a number of reasons for it. Number one, investigation agencies did not have that particular caliber to investigate them, knowledge about collection of digital evidence. Then even law did not have the proper procedures. So what the criminals are doing, they are exploiting this particular drawbacks, gaps. So we need to put in the procedure. Because otherwise what would happen? It would be, now you are hearing about the Nigerian scam, and I am telling you, in the way things are going, after 5 years, this would not be a Nigerian scam, it would be an Indian scam. Because as a lawyer, when I am looking on the cases, you may be looking from different perspective. For the every case which is coming to me, it is with a different perspective.
Yep.
Sir, you told one thing regarding the when we are taking the memory dump and all. So you have to put the software like Memorize or whatever you are using, volatile framework, volatility framework you install. You told it do it from the USB drive. If we maintain a proper audit trail and we are making entry in the chain of custody form that the investigator install this to take this, because you will have to install it with administrative privileges. For running any XE also, you have to do that on that machine only. So is it that
you can do it,
yeah.
but if you can do it from the external pen drive, like using FTK major light version, so then you would have a minimum impact on the address. So that is one of the principles. But if you do in that manner also and you make the proper audit trace,
So
then there is no issue. But when the problem
Audit trail is
to
very
convince the court,
yeah.
Like basically you should be aware about
you
what
should be aware about the consequences what you are going
And
to
it should docket it and very very clearly mentioned in the chain of custody and the audit trail.
And the file times when access times will match the times in the report. The
Yeah, file
prosecution.
time is a very big,
Yeah.
it's a very relevant issue. I tell you one of the recent case about 3 days back. Crime branch conducted a raid and they recovered one of the laptop, which was alleged to be containing a clip of a girl prepared by 3 or 4 persons. So the case was registered on the complaint of that girl. They have prepared some nude clip of that girl. So now the IO called me, sir, whether I should access it or not. Not tell me what is your answer.
It was there sir, on the PC. On the
On the laptop.
You should not access it.
You should not access it.
Or even if he's accessing it.
Now see, I agree with you. He cannot access it. No, his
You can
query
put a-
was.
you can put a right block on it.
I agree with you. His query was, if I don't access it, I have to release these 3 guys. I cannot arrest them because I did not have any material to show to the court.
Then make an audit trail.
If I want to take the remand, I cannot take the police custody remand until I will show the court that I have such a material. Third, even if I arrest them and after 1 or 2 years forensic lab give you opinion there is nothing, then who would be held liable for the consequences? I agree with you. They can put the right broker, they can make the mirror image, they can do all the things, but these facilities are not available at the police station level or at the district level. Even for taking that, these facilities in an urgent manner, they require 2 to 3 days. So what I told him, okay, you go ahead, you access it, but do not access the file. When you have some file which you suspect, export that file into pen drive, right? See? Open that in a pen drive so that the properties of the original file should remain intact. And you should audit and record this process in your seizure. Now, in this way, he would have evidence to show to the court. He can maintain the metadata of that file. So, whenever the forensic opinion would come, it will show that what is the modified date, access date of that particular file.
But even if we
So, sometimes, depending upon the circumstance, you have to maintain that balance.
No, but sir, even if you're copying a file, it will change.
It will change.
It will not change.
It will
Because the
It
file
will not
is
change.
still in the system. We are making a copy of it in our
It will not change.
You are not open it. You have
Access will change, right?
So access will not change.
none of the
It will not
Some
change.
metadata will change.
No, nothing.
No metadata about it. Accessed and all those things.
Nothing will
Even
change.
nothing,
MSC
no code in the computer that you have made a
You
copy.
made a copy.
MSC.
The law would be only of the pen drive which you have connected to that computer.
So the same question which I was about to ask you. So over here, the primary evidence over here for a video clip, if it's transferred, the hard disk of a computer is typically a media. So would the primary
Primary
gadget,
evidence would be the laptop.
yeah, so the primary evidence, shouldn't it be the video camera from which the video clip was typically shot, because somebody transferred.
See, the primary evidence would be video camera only in case if it is into the memory of the video camera. If the original is prepared in the memory of the video camera, then the video camera would be the primary. If you have used some external disk or memory card, then it would be the primary.
So typically all the video files, the primary media, the primary gadget with which you shot it is the camera.
So then it would be camera.
And all of them are being typically transferred to a hard disk and then...
Now it is not so.
Okay.
All the investigation agencies now they are using the gadgets having the external hard disk for memory card. Now, even based on my recommendation, CBI is using the digital voice recorder with the external memory card. Right? So third, we need to prepare the hash value of the data. So how many times hash value is computed during the life of a digital evidence?
No, okay, one question here. Now,
First my question, answer my question. How many times you will
After
compute
you-
the hash value during the lifetime of a digital evidence?
पहली बारी करोगे बस
जब
once you are imaging it तब आप एक बारी करोगे उसके बाद once you are starting analyzing तब आप देखोगे hash आपका वही है.
See, first you will make when you will seize it.
See one time.
Right? That is the original hash value. Second,
Second time
when you will make the image.
Image को जब हम काम करना शुरू करेंगे image
When you will make the image, you have to make it sure
Correlate.
that the hash value of the image matches with the original.
वो तो
Right.
उसी time.
Third,
When you are producing the evidence in front of the court or somewhere.
When you start working on it, when you start working on it, before working, I compare.
no. This is the most tricky question. When I was giving examination, my examiner has given me 15 days and I was not able to find the answer. So third is, suppose now you have a mirror image, you have started the forensic process. You are expected to use the right blocker. Because otherwise what would happen? You are applying number of process on the hard disk. But if evidence is contaminated during one of the process, let us say for example in the first process there is tampering, it would become an input for the next processes. So with the contamination of evidence, your result would contaminate it. So the third hash value is computed of the mirror image after the forensic process is complete.
सर हम लोग को मतलब but before भी करते हैं सर.
Before तो करते हैं, before is always because before when we are making the image, we are doing that. ठीक है ना? That you are doing at the starting is that is just to make ensure, but mandatory requirement are these three. When the original is seized, when the mirror image is prepared, when the forensic process is complete.
तो ओरिजिनल सीजिंग के टाइम पे सर एक ही बार ही होता है ना. अगर हम 3 टाइम्स की बात करें, फर्स्ट टाइम द हैश इज ऑटोमेटिक कंप्यूटेड व्हेन आई एम सीजिंग अ हार्ड ड्राइव, तो उस टाइम ओरिजिनल और मिरर तो साथ में ही
नहीं इसमें डोंट कंपेयर द मिरर. फर्स्ट यू विल कंप्यूट द हैश वैल्यू फॉर ओरिजिनल.
सोर्स क्या है?
सोर्स की
पहली बार एक ही बार होता है.
नहीं दैट वुड बी टू प्रोसेस.
आप दो बार अलग कर रहे हो.
Both are always different in the forensic process.
Both are even different, na?
Because even that, see, even during mirroring process, there may be tampering. Then your equipment may fail. So, as a forensic principle, first hash value is computed of the original. So, next stage is creating the forensic duplication of original data. So, we are preparing the mirror image. So, what type of backup or mirror image we prepare?
Bit by bit.
Then there may be different version in bit by bit.
Bitwise तो सर आप बताइए what version आप हम तो एक ही.
I want to get answer from you. How many type of forensic images you can prepare?
5 by 5.
One is the mirror image, right? Cloning.
Formats की बात कर रहे हैं.
The main you can
DD format कर सकते हैं और
you see,
FTP
the main thing is the forensic copy. The word which is used at the root level.
Yeah.
Root level. Then we have the two separate versions. One is the mirror image. Second is the forensic backup or clone copy. Forensic backup is hard disk to hard disk.
Yes.
Right? And mirror image is a image file.
Yes.
In one hard disk you can have a number of image files.
Yes.
So you need to know the difference about it.
But the same thing, sir. I can, if I have a suppose 1 TB image and 1 TB hard drive, I can restore that.
You can restore.
Yeah, it's the same.
But
technically same.
Technically,
I agree what you are saying.
But they are different. Though mirror can again be converted into backup.
Exactly.
Then the last one is the log all investigation detail in the report, your audit process, chain of custody form. So now I am coming to the admissibility of the electronic evidence. So when Information Technology Act was passed in the year 2000, Evidence Act was also amended to include the word electronic records. So in the law, it only identifies the electronic records, and electronic records are equivalent to the document. So court does not know what your hard disk is. In the charge sheet you mention document number so and so, it is hard disk. So they are equivalent to the hard disk. It means if you are filing anything into the court of law in electronic record, you have to give a copy to the opposite. So that's the. So now this is a judgment of Anwar P.T. Then it's a very important judgment. I would like all of you to know. Because only by virtue of this judgment, CBI is going to lose 50% of their business. So this judgment says, original evidence is admissible under section 62 of the Evidence Act. If it is a copy, then it would be admissible by virtue of section 65B of the Evidence Act. Under section 65B, a certificate has to be attached. Then court has stated that if there is no certificate under section 65B, even no expert opinion would be admissible in the court of law. There would not be any oral testimony to that evidence. I tell you how it affects the case. Till 3 years back, what the CBI was doing, when they were going on the spot, they were going with a digital voice recorder. They used to record it, and as he told, after recording it, they used to shift it to a CD and file then they sent that CD to the forensic lab. Forensic labs used to give opinion on two aspects. Number one, that it is a authenticated data, there is no tampering. Second, voice in the CD matches with the voice of the accused. And it is being forwarded into the court, and on the basis of that, conviction is done by the court. Now, what happened after this judgment? Original have been deleted in the DVR because they shifted the CD data on CD. 65B cannot be given. 65B cannot be given. Then whatever forensic opinion it has been taken on this particular CD, that cannot be looked into it. There cannot be oral testimony. Now the position is, whenever in such cases CDs are before the court, at the start of trial, court takes out the CDs out, forensic opinion out, that is all. So now this is not only applicable to digital evidence, it is applicable to every case. Even it may be of your any forensic audit report. And if the forensic auditor have not taken a authenticity certificate, and it is based on merely photocopies, then even that forensic audit report would also not be admissible. It may be report of your ISO 27001, any report which is based on certain documents. But if these documents are not admissible, then that report would have no value.
ये सर्टिफिकेट देता कौन है सर?
I'm coming. Section 65B, but it says, because it's very important section and it is relevant to every person who is dealing with IT or any type of forensic audit or any type of analysis or reporting. So 65B says, whenever any information is contained in an electronic record, like hard disk and any of the electronic media, and when you take a printout or transfer some of data into CD, DVD or external drive, and you are submitting it to the court of law, it would be admissible. Without production of original, you are not required to produce the original, provided certain conditions are fulfilled. And now let us see what are these conditions. So we have conditions relating to computer, and then we have condition relating to the information. And this is very important. First, the computer should be used regularly to store that type of information. That type of activity should be regularly carried into that particular organization and computers. Computer should be under lawful control and it should be operating properly. Now, condition relating to the information, that information should have been obtained in ordinary course of activities. And information should have been derived from the information which is fed into the computer. So if these conditions are complete, then that evidence would be admissible as a secondary evidence, otherwise it would not be admissible. Again, it's a very simple example, practical. All of you might be receiving the bank account statement in your email from your bank. Now, if you have to prove a bank account statement in the court of law, whether that bank account statement is sufficient to prove or whether you have to call a banker. Now, let us see from this particular. You can say that my email account is regularly being used to store this type of information. This is being regularly carried out. It is your under lawful control. It is operating properly. That you can justify. Now coming to second part. Ordinary course of activities. But computer is not maintained for processing this type of activity in ordinary course. Secondly, your computer is not producing that output from the information which is fed into that computer. So which is the relevant computer? Computer of the bank. So you have to prove it from the bank, not from your own. Now, these two are very important points. Now, let us take for example, you have an account in Bangalore. You are now residing in Bangalore. You require a statement for legal purposes. Which would be the computer? From where you will take? Bangalore computer, Delhi computer, or where the server is located? So it says, by the combination of computer operating over that period. So if number of computers are connected in LAN and WAN environment, they would be treated as one computer. So this is very important provision. And why it is also important, if you are in a company and maintaining some data in a database, you must make it sure that should be part of your LAN or WAN network. By different computer operating in succession over that period. After 3 to 5 years, hardware changes, software changes. So can you produce the same computer in which you have procured that information? No. So it says the computers which are used in succession would be treated as one computer. So that serves lot of purpose. So section 65B comes to your rescue in case of electronic information. So then content of certificate, we can mention what is the electronic record which we are going to prove. Device from where the output have been taken, and the condition regarding the compliance of the 4 conditions which we have discussed. Who can give the certificate? The question which you have raised. 2 persons can give the certificate. One, the person who is concerned with the operation of the relevant device. If there is a computer, the computer in charge, IT professional, head IT, branch manager, whoever is conversant with the or having some official position with relation to that device. Second, the management of relevant activities. Now branch manager is sitting there, he did not know how to operate a computer, but he is managing all the relevant activities. He knows how it took place, how the debit credit took place, how the account is being run. So he can also give the certificate. So any question for 65B?
Yeah. Like whenever we get asked for records from Yahoo, Rediff network, when they give the log access details and analytics,
they don't give the 65B.
But they write in the last they write is this is admissible to the court under section 65B, and this can be published to the court.
See, that is not the proper language. The language should be this is being given in compliance of 65. In what manner court has to make it admissible, it is not their way. It is the discretion of the court.
Yeah, of course.
They have to write that it is in compliance with section 65.
Yeah.
But when the particular witness comes to the court, as a defense lawyer, I can always cross-examine him. He tell me what is 65B when you are saying you are in compliance with 65. So that is subject to the cross-examination, otherwise it is.
Yeah, otherwise, if it's like something to do with OC and all, I'm very sure Official Secrets Act, the court directly acts.
There is no demarcation to that. The judgment of Supreme Court is totally binding, and only because of that judgment, CBI have already lost 50% of their cases, and under for 65B court is not compromising. So law is strict and clear.
No question. Another one doubt on this. Like we are talking about these evidences. Like we do have email, chats, records, and other things. Now in the chat record, if you are from the chat records of a criminal, you are able to see something. Now you are catching this guy on 30th or 31st. You are now taking over the account. You are analyzing the account. Now you document it and start chatting on it to find the full network. Okay. Can I say to the court that till 31st is what is admissible. After that, we use
You
it for.
are recovering it from accused.
Yes.
Then 65B has no applicability.
No, I'm just talking about digital evidence.
Yeah, I'm talking about 65 digital evidence because you cannot take a certificate from the accused because the accused cannot be witness against himself as per Article 19 of the Constitution. So whatever you recover from the accused, that would be admissible by virtue of Section 27 of the Evidence Act, not the 65.
No certificate from.
No certificate is required if you are recovering from accused.
No, that's what I'm saying. Does the court, if I say the court, whatever you see till 31st October, that is what is against this guy. After that, we used it for investigation purpose to crack the whole network.
You can always say
That is what I'm saying.
that is a part of investigation. That is a complete chain of custody.
Yes.
And that you will find in every case.
Yeah.
Because with the investigation, you will collect more and more evidence, but it needs to be connected in a sequence so that it can build a chain of custody. So there is no issue. So then coming to the preservation of original. Yeah.
For 65B, in the previous slide you were talking about multiple computers being part of the LAN WAN and them being considered as a single entity, right, by a combination of computers operating over that payload. Now in scenarios where, or have you seen scenarios where there was some record that was generated from a central server and it actually got contaminated in one of the intermediary computers of the LAN WAN, and then the defense actually uses that as a reason.
I have used in one of case, and I tell you what was the case. In one of the murder case, I cross-examined 6 of the nodal officers regarding the mobile data, CDRs. So in one of the case, they have taken the CDR from the service provider, from the home circle, and one from the other circle, like one from Delhi circle and one from Haryana circle. So in both the cases, the set of calls were different. Sometimes even duration was different. So we get the benefit of that. Okay. Next. So the another important factor is once you have given a secondary evidence with a certificate under Section 65, whether you are required to maintain the original or not.
Yes. Definitely.
So you have to make sure that original should be maintained. And law even provides that the accused can inspect the original. So there is a judgment of Delhi High Court in the matter of Dharmir versus CBI. The High Court has held that even if you have filed the secondary evidence with a certificate under Section 65B, still accused can inspect the original. Though court will not order to produce the original in court, but court may allow the accused to go with the local commissioner and inspect the original. He can do that. And in that particular case, the court have allowed. Under Section 7, which is still being not followed anywhere, metadata is required to be maintained. So metadata means if you are filing the email, you must make sure that you are filing the header with the mail. Right? Now this is, I think somebody has put this query to me in the morning. This is a computer generated statement and requires no signature. How many of you think that it is a correct statement and what is its cause?
This is just this is, I think, in my view, is only for an information basis as far as the evidence is concerned. Probably what I understand that it may not hold any.
See, law clearly say it has no source, but it is a legal statement. The document which contains this statement has no authenticity
It's only
whatsoever.
an informational basis.
This may be an information, but you cannot use it into any of the legal form. Yeah, please. Now see how the document would be admissible. If it is a simple document, it would be admissible as per Section 65. So it should be accompanied by certificate. Now the bank statement which you are getting with this statement, in fact requires 3 certificates. Because 65B is not applicable to banking record. Banking records are admissible by virtue of Section 2A of the Banker Book of Evidence Act, and which require 3 certificates to be given by the bank. And branch manager is competent to issue all the 3 certificates. So he can give one consolidated certificate. So if the information is coming from the bank, you can always take it with a single certificate. So that means whatever statement you are getting at home, you can never file it in the court of law. They are of no use. They are merely waste papers.
But one should obtain the signature. One should be able to obtain the signature.
So normally what they do, they will put a stamp that it is as per section 2 of the BPC. That's a small stamp, and they would sign. Then it would be admissible.
So it is digitally signed statement from Southern Banks.
Then digitally signed is admissible. Why it is admissible? So we have a separate provision on digital signature. So it says there is a presumption, but it is signed by digital signature. It shall be deemed to be admissible. So it is a deeming provision. Even the burden of proof shift to the burden of disproof shift to the opposite. Suppose if I find something with a digital signature and the opposite party say that no, it is not correct, then burden lies on him to prove it is not correct. So that's very good say.
I was visualizing another situation where you are in conflict with the bank itself. You say something.
Yeah, she has raised a very good point, which I missed. You are receiving some statement from the bank, right, which says this is a computer generated statement and require no signature. It would not be admissible in the court of law, but it would be admissible against the bank. Because bank is sending me. I have a proof that there is an email, they have sent it to me. So such a document would be admissible against the sender. Suppose you have sent something to me through email. Because of section 65B requirement, it would not be admissible against anyone else until I will issue a certificate under section 65B. Okay, but it would be admissible against that.
So basically,
because there is another principle of interpretation. We say once you have given something to me, and I am able to prove that you have given to me, then the burden shifts. Yes.
So nowadays a lot of commerce happens on email, and the digital signature are not that common.
Give me some time. I am coming to email. I will discuss about the email.
Okay.
Then we will see. So now coming to the hard disk. This is a very good judgment on the hard disk. You must study. This judgment says, when we have a new hard disk on which nothing is written, it is not an electronic record. It is merely a storage device. The moment you write something on it, it becomes an electronic record. Now you delete everything. So what would it do? It would continue to remain as an electronic record because we can record data from it. Then it says every hard disk contains two types of memory, active memory, which we also term as allocatable data, and subcutaneous memory, unallocable data. Right? Accused is entitled for both. So that means both constitute your mirror image, allocated and unallocated data. Right? So this judgment says that accused is entitled for the. So this is applicable to your pen drive or data into any of the hardware media. So electronic backup, now you see, now you apply section 65B and other principles. If you are taking the electronic backup, like disk shadowing or disk mirroring, so it is an automated process. Then section 62 of the Evidence Act says, if something is being replicated through an automated process, then all the copies are original.
They are original.
All are original. So if you are diverting your log to two email accounts or two different destinations with a single process, then both would be original. But if you are taking the physical backup or making a copy, then that would be copy and that would not be original. So in that way you need to make demarcation between the electronic backup and the manual. Same is about the log. How you are maintaining the log, either by way of electronic backup or by way of the manual. So if it is a manual backup, it would not be admissible because it would be copy. So if you are producing in the court a copy without original, even you cannot issue a 65. So then there is no procedure to make it admissible. And I have found in number of companies, what they are doing, they are taking a manual backup, original is nowhere, they are preserving it, they can never use it in any litigation. The only thing is if the defense counsel does not know how to object it, he did not know about the logs, then it may happen. But
so the printouts of these original electronic backups, are they considered as original?
Original, they would be secondary and they should be accompanied by 65B certificate, okay, so then it would be admissible.
So they are still they will be considered as secondary when you take out the printouts.
Any output which is taken on the printout, CD, DVD, pen drive, any external medium, it would be secondary.
I have a question. So many times we have these financial fraud cases, you know, EOW and all these guys. So when suppose a banking system is compromised, अभी Axis Bank और उनके साथ भी हुआ है. Now we want to present the evidence. Generally ये system के logs जो होते हैं, syslog नाम का एक software use करते हैं हम लोग, उसमें logs maintain होते हैं. System के अंदर तो कुछ होता ही नहीं है. All the transaction logs, access log, hacking logs, everything is on that syslog server. अब वो syslog server में how can we apply this evidence act? Technically वो
syslog in the syslog, it is an automated process.
Automated process syslog में
so they would be original.
Original माना
They would be original. That would be electronic backup.
It's not exactly a backup, but consider कर सकते हो.
You can, it is a mechanical process.
जैसे हमारा ये CCTV लगा होता है, उसका DVR recorder होता है ना. अगर मैं physically बात
They are connected to each other.
Exactly.
They are connected over network. In real time. It is in real time.
Yeah.
So then it would be original. Because there is the explanation to the primary evidence, section 62. It says if something is being reproduced by mechanical process, all the copies would be original. So if you divide it to number of mail ID in a one go, then all would be original.
कई बार हम मेल्स भी देते हैं. अगर कोई क्रिटिकल प्रोसेस हुआ है, किसी ने लॉगिन किया है, तो 5 एडमिनिस्ट्रेटर्स को मेल चला जाता है. So that will be second.
Take a safe write in Oracle.
That should be the automatic process.
Automatic ही होता है सर.
If automatic, then it
वो सिस्टम ही मेल भेज रहा है कि मेरे साथ अटेम्प्ट हुआ है तो 5 जगह मिल जाएगा. So will that be a original evidence? Mail ID जो मेल आएगा.
Then see that mail ID is being sent subsequent to the logs. Right?
Yeah.
So it is not with the automated process that moment log is generated and copy is being sent. If it is so, then it would be original. But if there is a gap and something is being sent later on, then it would be scanned.
So basically syslog is a good way to maintain the
best way.
Best way, right? क्योंकि वो
it would be original. Yes.
Good. An extension to what there's a question on the syslog. Once we move beyond it and we harvest logs for analysis, and then subsequently if we have an incident extracted out of it of corporate espionage or something of that sort, would that be admissible in the court? I mean the logs after doing the analysis.
Yes. In the court, you will give the original copy. Analysis copy you can keep for yourself. See, it is similar to we have the original hard disk, we have a memory image, right? We work on the image,
right,
but we forward to the court the original hard disk.
Right. Now.
So, but here your thing is, you have taken some of the log, you did some analysis, you arrived at an opinion that some attack is there or some manipulation is there or something like that.
Right.
But in that case, when you are filing before the court of law, you should file directly from the original copy. That would be the proper process.
Right. If I could just take one more minute. The originals wouldn't give an impression that it's an attack. But if you correlate
you can attach your analysis with it.
Okay.
You can attach your findings with it. But you should mention that your findings are based on the original law, which are attached here with the answer.
So let me tell you where he's coming from. So let me introduce him. He's from RSA. So they have a very good product which we call as Envision. So probably are you on the same?
Yes, Envision is out now. Security analytics is the one.
Yeah. So basically, it's like syslog on steroids. So syslog is more like a logging thing. They have a solution which can actually gather the logs and it will give you a very good report.
Some type of SIEM.
SIEM. It's kind of a SIEM solution. So a SIEM solution now it's a proprietary log.
But see, in case of SIEM, if during when the logs are created and by automated process one copy go to SIEM, then it would be original.
So now my question,
it depends on whether you copy, download and transfer it to SIEM or automatically it goes.
Automatically it goes.
If by automatic, then it is original. If you import and transfer, then it is.
Achha, one more thing, sir. So now, what about this authenticity or admissibility of the SIEM logs in the court of law?
SIEM logs, that means analysis.
Analysis, yes.
So analysis has to be. That is your opinion.
Yeah,
a person who is an expert. Now you have done CHSS, you have the adequate qualifications. You go there, prove before the court, and explain how it has been done. And you are also required to prove the authenticity of SIEM tools. Because earlier I was discussing about the open source tool. If it is open source, you may not be able to prove the analysis. Then you have to prove it manually.
So
by explaining the process.
What if I have my electronic backup generated using an open source tool?
Yeah, we have Greylog with
You have this automated, it's still automated.
Now you can divide it into two parts. Number one, the logs have been transferred, automated process into an open source tool.
Yes.
That is the first part.
Yes.
Second part is the analysis done by the open source tool.
Yes.
Yes.
So till the first part it is original. For the purpose of analysis, you see, it is possible to create a software which can do 2 plus 2 4 and which can do 2 plus 2 22.
So let the prosecution verify it, na sir?
See, burden is always on the person who want to prove. If you are going to prove a case, burden lies on you. How the prosecution would prove? Prosecution did not have that software. Prosecution is not doing the analysis. So the best way is, if there is an open source tool, you should download the source code, and while forwarding the code, you should also forward the source code.
Acha.
That means now you have all the source code before the code, which shows the process, flow chart, how it has been done, what logic have been used, right? Now the burden would shift to the defense to prove that this source code is not able.
So basically, what you are saying. So let me give you a way. So पहली बात तो sir, not everyone can afford all these lakhs of rupees of NKs and FTKs. I am being very. So that open source thing which you have mentioned, it's a very nowadays it's a very problematic thing for many experts. Because not everyone can afford that. So बोलते हैं open source tools analysis है सीधा मान्य नहीं है कोर्ट में, and that happens.
नहीं, if you attach the source code, then there is no.
So basically ना जरूरी नहीं है सर हर open source tool का source code available हो. There are many free tools like by Mandiant also. Volatility जो volatility है वो free है. काफी सारे tools हैं which are better than. अब FTK मैं आपको एक केस बताता हूँ. FTK in case they cannot do jump list analysis of Windows, वो नहीं कर सकते हैं. हमने एक केस सिर्फ jump list analysis के through solve किया था. This tool was developed by one of my juniors from my university. काम solve हो गया था. But now coming to admissibility, what to do? अब आपने open source की बात करी.
Another way of doing it. If a person who has developed that tool, he can come before the court and give a deposition. Then again it would be admissible.
But how can that be possible, sir? People from all over the world do it. And
then there is another way of doing it. Is by the circumstantial evidence, because it is a weaker piece of evidence. If you can corroborate it with some other evidence also, like finding of jump list is corroborated by some other evidence also, then even the court would.
By statement of the accused.
Statement of accused is of no value.
By the statement of the victim.
I don't think it would. It should be some.
So how can we?
Can someone depose via Skype or Hangouts? Can someone depose via Skype or Hangouts if he or she is not physically available? Just say in this case, the author is not available in India for this particular utility or tool. Can they depose via video? No, they have to come.
So, again, coming to the open source part, like SANS comes out with SIFT tool.
Yeah.
And SIFT tool, you can do anything and everything using SIFT tool, and much better than NKS and
FTK. Yeah.
And SIFT tool, of course, they give.
It's open source.
It's open source, and the site they give, if you want to really bundle it and configure Ubuntu, they give the source code. Those things are there. But using SIFT, if I do the end-to-end forensics, then what is that?
See, there is. I have told you, until the authenticity of the tool is proved, code may not make it admissible.
Is it written somewhere sir, that only licensed softwares, like, is it some statement there?
No, there is a double principle which says that the tool should have been approved by the community and also scientific process. Both should be approved. There is international law on it.
Sir, one more thing. You are talking about the community review, right? Scientific community, or there should be some papers or anything on that. So I have a solution to it. You please give your 2 cents on it. Suppose I download a software, a utility.
Anything you are downloading from YouTube is not admissible.
No, not from YouTube.
But I tell you.
Let me complete, Neeraj. Let me complete. What I am telling you is that let's suppose I used maybe like volatility framework. Okay, it's from Mandiant, and I use that software. It's open. It's not an open. It's a free tool from the company. And what I say, I've used this tool. ये इसका setup रहा. I also give in the CD. I give the setup of that tool. I give the hash of that tool. मैंने कहा ये setup का hash है उस folder का पूरे setup का. This is the hash. And you compare this hash on the website. वो जहाँ उसका setup है, वो version का, उसका hash और ये hash same है. Which proves कि I have got this software from that. I have used this software and the hash is also the same.
That's where the practical problem comes. The case I was discussing of open source tool with you in the morning, in that case the charge sheet was filed in the year 2008. Now it has come at the stage of draft.
Okay.
And after the 8 years, you will not get that hash value. You will not get that version. Even you will not get the compatible version. Even if you want to use that software now, you may not be able to use. So these are the gaps because of which it will not be admissible. And that I tell you other ways how you can make it admissible. Suppose like NKS-FTK, why they are admissible in India?
That's stupidity. I'm being very forthright. Because the legal people are not aware. Resource hacker is a tool. NKS cannot do what resource hacker does.
And this is not the reason. Reason is how the code should be convinced about the authenticity.
Sir, at just one point, sir. We have a lot of organizations in our country. In Trivandrum, we have Foundry Lab, we have Hyderabad Lab. Why don't they give a codes a framework which is certified by them and tell open source this is a comparison? 25 lakhs, 30 lakhs we are paying US companies just
see,
so this
you are asking about the solution.
No, sir, I am
discussing about the
discussion. Since we are at a
so now the government have entrusted this project to NICF to create a framework whereby they can give some authenticity to the open source.
And secondly, so there are empaneled vendors across there, like who are empaneled with Ministry of IT. So they also have a say. They have the government has a complete process of getting those experts on board.
Whether you have seen the picture of Judge with a he don't know anything, right? So what are the other ways I am telling you? Normally you can bring some judgment of the foreign, like what the FTK and NKS they are doing. At the initial level, they come with the judgment of various US courts saying that they are admissible. So if you are also able to withdraw some judgment from there, then court could be convinced. Because once the defense is saying that this software cannot do anything, then again they have to come with some logic and something more.
So that's a very
so if you can bring some judgment, so you can. That's the best way of
all these tools, resource hackers, safe, volatility, thousands of judgments are there across the world, especially in US.
So how you will prove the SMS in the court of law?
Prove the SMS.
SMS, how you will prove the SMS?
How we will
prove the SMS?
From the
CDR?
From the mobile ISP?
Original mobile is required. Simple original mobile. And the second part is, because SMS can be spoofed, so if we have the mobile detail of both the parties, then even we can detect whether it has been spoofed or not. Third, forensic analysis of SMS is also required because now there are a number of tools are available by which you can even change the content of SMS. You send me SMS, I alter the content, make it a cognizable offense. So it is required.
I would say only the CDR is the proper way.
CDR doesn't show extra SMS.
CDR would only prove whether that SMS is good. For the content, you are required to have the original mobile.
That's right. This is what. So the same.
Now coming to the email.
Just a little doubt on this now. So that is what actually the all these lawbreakers will do. They'll throw away the original mobiles, and even if the same is same, and you can track it, and you know you can't do anything about it. Then in that case.
But you can always get it from the complainant, because you can have at least complainant with you, but then you are required to see the mobile of complainant. So coming to the email, who will give a certificate under section 65B in case of email?
Google will. मैं दे दूँगा सर मेरा email.
नहीं Gmail, either the office of Gmail, either the office of Hotmail, either over.
Sir, now computer is owned by me. Let me talk about legal. Computer is owned by me. Okay? Let's not talk about Gmail, Hotmail.
But whether the mail resides in your computer?
Mail is residing on my computer.
In Outlook?
In Outlook or in my Apple Mail. So I would say I will keep the certificate original.
No,
or maybe my company
owner. Mail service provider. The example which I gave is actually this.
Section 88 is a presumption. It's a very important point I am telling you. I have delivered a number of lectures in judicial cases. So even judges have issued the certificate notice to Gmail and that email. But section 88 is a presumption which says whatever message has been sent, same has been received by the opposite party. So this is a presumption. But there is a no presumption who has sent and who has received. So when there is a presumption for the transit, then no certificate is required from Gmail and Hotmail or Yahoo. So we don't require any certificate from ISP. He is right. If he is having an email account, he wants to prove that email, he can take the email, he can give the certificate under section 65B.
Exactly.
So certificate can be issued by any of the parties to the mail. Now who are the parties? Sender, receiver, then CC.
Carbon copies.
CC people. Okay.
So that's why in the foreign countries you will find that it is a matter of practice. In all official communication, they keep one person into CC.
Yeah.
So the person who is into the CC comes and prove. So that's the best way. Only the challenge is when we require it from the email server, when server belongs to a private company. Like you are employee of Tata.com, you have an email account of Tata. So in that case, you need to have a certificate from that because it is not it may not be an independent service provider. It may have an interest.
So now one question. So there is a case of there is a presumption, basically not exactly a case.
Then presumption would be rebutted now because the presumption is given to you for ISP only. When you are an individual company, you does not fall within the definition of ISP. So that is the.
But so generally people take services from either Google.
Then there is no issue. Then there is no issue. So I am telling you,
email will be on company. Email will be on suppose Vigilant.com, right? But जो सर्विस ले रखा होगा वो Google या हुआ किसी क्लाउड सर्विस से ले रखा होगा.
But then it has to be brought on the record that they have taken the services from Gmail and Yahoo.
अच्छा वो दे देंगे तो फिर
वो दे देंगे then
there is no certificate. Or the Vigilant people can give the certificate. वो भी दे सकते हैं.
They can have some contract with them. They can give the copy of contract also that we have contract with Gmail or something like that. We are using the services of an independent service provider. Then it would be admissible. Then we don't require any certificate from ISP.
अच्छा. तो सर इस केस
email header, because you know spoofing email is the most easiest.
तो email header भी change हो सकता है सर. If I am giving a printout, I can just change the email header and give it to you.
You can always manipulate it, but then again you are giving a certificate under section 65 with it. So if it is a false, then you are also liable to prosecution. And I have earlier discussed that even accused can move an application. Okay, show me the original mail. Open your email account, show me your original.
So now for
example,
example,
if you can show the original, then there is no issue. So there are a number of factors to it. Number one is, suppose the accused object or not object. If they don't object, then there is no issue. Right? Then suppose you have a number of mails, one mail preceding, succeeding, which are also being proved. So court can also see the circumstantial evidence. So even the opposite party may object, court may still make it admissible, looking upon the conduct. Suppose there is a one mail which is into question, but the opposite party produce the other number of mails, subsequent mails, which contain the preceding mails also. So that also depends on the circumstances.
So now coming to the commercial angle, somebody sends someone a purchase order or over email. Now it's not stamped. Generally, आजकल ऐसे ही काम हो रहा है. Even us, even everywhere else. So now what is the value of it? Like suppose HCL gives me an order.
I have already discussed it with you. If you are sending a mail to me and I am able to prove you have sent it to me, I can prove it against you. I cannot prove it against rest of the world, but I can prove against you. That is a principle of interpretation.
So I can say that they have given us an order and
then you have to prove that this is the mail which has come from them, this is mail, this is header, this is the IP. If they challenge, then court will see depending upon the circumstances. If they don't challenge, then it would be admissible. The only thing you have to prove that they have sent it to you. And now if there is a person into CC who also comes to the court and say that I have also received the same mail, then it would be admissible. But producing it from Outlook may have another challenge. Because if you have an email in the Outlook, you simply click, right click on it, edit it, save it. So you can manipulate it.
Yes.
So I have come across a number of cases where the person has
manipulated
it and filed it in the court of law with a certificate under section 65B. So then I have filed the application. I want to inspect the original. Now they are running, sir, I have used the password, I have used my laptop, I don't have this. Now these things are going on.
Okay.
Data in a mobile. So mobile and computer are same. The definition of computer in the law is any instrument which had three functions: arithmetic, memory, and logic, is a computer. So if maybe your washing machine having all the three functions, then it would be computer.
Nice.
I have tried to make it most relevant for the IT professional, and I have enjoyed the discussion very well.
So I have one more request for you. I have one more request from all of us. So most of us are IT professionals and most of us work in information security. So if you can give 3 pointers that can make the, so God forbid any fraud happens, but if the fraud happens, only 3 things you give us. If we do these 3 things, then it will make the life of the forensic investigator, the lawyer, and the corporate management and the IT people easier.
And admissible to a court.
Admissible, easier.
First of thing, you should develop the procedure that always original is present. Like if you are diverting the load to sys load, you can divert at the same time at 2 places.
Okay.
Right? One you can keep intact. Whenever required for code, you can give it from there with a certificate under section 65. So it's a very simple. Right? Secondly, you never work or contaminate the original evidence. Whenever you have to work, suppose you have to import that log into SCM2 and you have to do some work, you can always have a copy of it, but never work on the original.
So there should be a syslog in each company. So technically I am translating it for all the servers. There should be a syslog server in each company which is taking logs of all the devices and computer devices in that, and nobody is touching it.
Nobody.
And वो 4, 5 साल 10 साल के वैसे ही रहेगा. That's what you are
And
saying.
whenever you are
generally sir, the practice is we have one syslog server and उसी पे लोग काम करते हैं.
Then it is not admissible. I am telling you, I have come to a number of corporate where 99% of their data has no authenticity. If tomorrow any case is there, they would not have any remedy. And even as of now, if they have any remedy, that is only because of ignorance of lawyer or ignorance of judges. But you see, now we have a judgment of Anwar Bibi, sometimes another judgment will come and it will take away all the other cases. Like they issue metadata. Nobody is submitting a metadata in court. In every case where I am objecting, they did not have any answer. Because court did not have any answer. So the main thing is that you should develop the procedure in your corporates which should have the inbuilt safeguard for taking care of all these issues. Rather than to keeping it to an individual or making him responsible, make the system work like this.
I know this will extend by 2-3 minutes more, but would the standards like FIPS and other international standards help us out in Indian courts?
No. Reason being the standards are relating to the international standard. So in every country the practices are different. Earlier 65P was in UK. Now UK have given up that practice. There you don't require any certificate under section 65P. In US you don't require. In India you require. So you can't apply the same. So you have to make it customized or tailor-made. Anyone else?
I was just thinking, if all else fails, you ask for 3 things, right? The third thing could be contact Mr. Neeraj. First consultation free, after that.
So I have seen some cases happening, just for information of people. If somebody thinks the law is still beyond, so I have seen cases happening in which the chain of custody form is prepared 3 दिन बाद में. वो तो आप समझते हैं पुलिस कैसे काम करती है. So all these procedures is fine, but still ये जब चेन ऑफ हमने कहा हमने चेन ऑफ कस्टडी नहीं है, ये नहीं है एंड एवरीथिंग. सो उसको पहले जेल में डाला है केस में. 4 दिन बाद उसका सीजर मेमो बन रहा है, सब काम कर लिया, जितना कंटामिनेट करना है सब कर लिया, उसके बाद वो बना रहे. मैं नाम नहीं बताऊंगा ऑफिसर का, आप जानते होंगे उनको. सो दैट इज ऑल्सो वो उनको पता है कि हाँ पकड़े जा सकते हैं, लेकिन उनका काम पूरा है.
This serial number is
let me be on the opposite side.
Yes, this is the problem. Is when the entire problem will come when the accused now counter challenge.